Hey guys, are you ready for more trial? For more cross examination, more speaking objections, and lawyers arguing with each other and the judge and the witness? This witness is kind of spicy too. Court is not back yet, but Court TV has turned off the elevator music. So, I think they are probably about ready to start back. Or maybe not. Who knows? I'm trying to make an emoji. I do not want to tell you what it is because it's a surprise. But YouTube is not cooperating. And it's ticking me off. I guess I'm going to have to talk to Bill again. He's probably tired of me asking for help. But he's the one that helped me make the emojis. And I'm doing it the exact same way. And it's just not working right. It aggravates me when I can't get stuff to work that I've done before and it's worked. Does that aggravate you? It aggravates me. And then I throw a temper tantrum. I'm 56 years old and I still throw temper tantrums. There's a shirt that I want. I don't remember the exact wording. It's something like warning, we'll throw video game controllers or something like that. Because I have literally done that. I've gotten so mad that I have thrown a video game controller across the room. And Travis was like, that make you feel better? You're gonna break it, you're not gonna be able to play the game at all. I don't care. Yes, it made me feel better. Oh goodness. Well, I found some nice pictures of what I want to make an emoji out of. They're not working. So I said, okay, I'm gonna try Canva's emoji maker. And their emojis are just little picture board. You don't have to settle with the little cartoony pictures. I was gonna make pants on fire, like liar, liar, pants on fire emoji, pants on fire, and got all these cute little drawings, but they're so intricate that they're not gonna work for an emoji. Because when you make them teeny tiny for an emoji, you can't make out the details. I'm like, well, what good does that do? So I don't know. I got her, I guess. But then when I watch a video about making an emoji, it just kind of tells you, well, go to Canva and make an emoji, and then this is how you upload it to YouTube. I got the uploading to YouTube part. I know how to do that. And then when I try to upload something, it says, there was a problem. Please try again. But it doesn't tell me what the problem is. If it would tell me what I did wrong, I could fix it. But it won't tell me what I did wrong. How about be helpful, YouTube? How about give me some advice as to what to fix? They might as well just say, figure it out on your own. Because that's basically what they're saying when, there's a problem. Tell me what the problem is. Stupid. Like, I go around now all the time going, stupid. I've watched too much of Shane's Dumb Criminals. Stupid. I love him, by the way. If you haven't checked out Shane's Dumb Criminals, you need to, because he is hilarious. I love him so much. He's also got really pretty blue eyes, so if you like blue eyes. My husband has really pretty blue eyes. I love blue eyes. My daddy had really pretty blue eyes. I was mad that I didn't get the blue eyes. My mom had brown eyes. Mine are hazel. I kind of got like a mix of my mom's and my dad's. And I had a boyfriend that said that my eyes turned green, this really pretty shade of green, when I got angry. And he used to start arguments just to watch my eyes turn green. That's why he's an ex. That's why he was always starting arguments. And then in the middle of the argument, he'd go, "Your eyes are that really pretty color green that I like." Shut up. Canva. Okay, on Canva, Canva is retarded. I didn't, because my eye again, I was getting I used the free version at first. And then I got the paid version, like and then I started paying for it again because I like the background eraser, and that's just a one-click button. So I figured, okay, well, I guess I'll pay for it, and I'm gradually learning how to do the other stuff now. So it's worth it now because I'm gradually learning, and eventually I'll have it figured out because I do know how to do more things now. But it's not a very user-friendly program. To download and save things, you click on share. There's a button up in the right, it says share. So you click on that and then it says download, which I don't know why there's not a download button. You gotta click on the share button to download stuff. But I want this emoji to be a surprise, so I can't have any of you guys help me, and then it won't be a surprise. I hate when I get text messages from unknown numbers. Oh. The dispensary has got some new system, so I get weird text messages from them. From an 800 number. It doesn't say that it's from them when it pops up anymore. And it says my account has new notifications. I'm like, what does that even mean? My account has new notifications. Okay, see, that took me, I'm pointing at it like you can see. That took me forever to figure out. You go up to the top left and click on file and then new design. And then you can start over and make something new. Because I was like, how do I get rid of this to make something different? So, because I would, like, with my thumbnail, because that's what I used to make all my thumbnails. So I would take an old thumbnail and just delete everything out of it and put new stuff on it. And I was just reusing the same thumbnail over and over and over. And then, like, if I needed to reuse an old thumbnail, it would be gone because I had deleted everything, and then I'd have to start all the way over again, and it was so frustrating. So now what I do is it saves it in your project file. So you click on projects and everything is still there. So now what I do is I go file, new design, and then I click on projects. So if we're doing Phil Spector, I pull up the Phil Spector project, and then I click in, like part whatever we're on, I click in that, and then I change the number. And then I download it again, and then I change the title in my download file, so then I can upload it. to YouTube. And then like for this trial, I click on file, new project or new design, YouTube thumbnail. And then I put this on the screen, and then I just change it to day, whatever, morning, day, whatever, afternoon. And then so that's
Counsel, any matters to address before we bring the jury back in?
I'm done.
I'm done, Your Honor.
Okay, we'll bring in the jury.
It takes a lot. Canva's not easy. It's not. Which is why I didn't pay for it for the longest time, because I'm like, this is not a user-friendly program at all. And then when I quit paying for it and they asked me why I canceled it, I said, because I can barely use the free part. Why am I going to pay? Because I can't figure out most of the free features, and the pay features are even harder to figure out. I let them know it's not a user-friendly program at all. I mean, I'm sure I can find a video that will teach me how to use it, but I don't have that kind of patience. I just don't. It's blurry.
Good afternoon and welcome back.
I guess it wouldn't be though.
And sir, you're reminded you're still under oath.
Yes, Your Honor.
Thank you.
It's
And
cute out
Mr. Blair, continued cross.
Thank you. Mr. Trinkle, I want to talk to you about formulating a hypothesis, if I can. Okay.
I'll see what I can do with it. I'll play around.
There is some common sense that's used in this, correct?
I would hope so.
Because, I mean, hypothetically speaking, and this is very hypothetical, an alien spacecraft could shoot a laser beam into a house. That could be a hypothesis, correct?
It would be wrong, but it would be a hypothesis.
Fair, and that's what I'm trying to get at. There are some hypotheses that are just automatically discounted because they're very illogical, correct?
Yes,
And not likely to have happened, correct?
correct.
So when we're talking about considering hypothesis, we're talking about what the investigator may consider to be a logical hypothesis, correct?
Correct.
Based on maybe the circumstances that they observe, correct?
Yes.
And is it fair to say that one investigator might look at the work of another investigator and maybe come up with different hypotheses? Is that correct?
That's correct. One of them would be wrong, if not both.
Well, and that's what I'm getting at is this is your work in this line of work, this fire investigator, it's subject to interpretation, correct?
To a point.
And so therefore, you may reach one conclusion on something and somebody else might reach a completely different conclusion, correct?
And as I said, if that's the case in something like this, either one is wrong or both are wrong.
And obviously, you're not reaching any conclusion here today, correct?
My conclusions are that I, with the information I have, cannot make a conclusion other than undetermined.
Fair. You were asked questions about the red gas can, correct?
Yes,
And you at one time were a government investigator working for the city of Detroit, correct?
I was.
And you were trained to collect evidence, right?
Yes,
And if you had gone to a fire scene and seen a gas can out in the front yard, you would have collected it too, wouldn't you?
I believe I would have, yes.
So you take no fault in the fact that Mr. Leroy collected that gas can, do you?
No,
Because that's data, correct? Or possible data.
possible, and that's why you do it. You know, then you do the analysis and all the other things, but yes, you'd collect it.
And you were asked questions about there being an ignition source in the living room. Do you recall those questions?
Yes,
And there, in fact, was an ignition source in the living room, was there not?
yes,
It was the fireplace, correct?
Yes,
Because we know there was a fire going in the fireplace, correct?
yes,
And those are based on the statements of Ms. Stermer, correct?
yes.
Were you aware that we heard testimony about the boat that was used to move Mr. Stermer yesterday?
Heard testimony. I've heard different bits of testimony. I'm not sure what you're referring to, however.
Fair. Did you hear the testimony of Trevor Stermer?
I didn't know. I was in the conference room. I wasn't allowed to be in here for that.
Would it surprise you to learn that it was a 6-foot plastic boat?
No,
Would it surprise you to learn that it never had a gasoline engine on it?
never had what, sir?
Foundation.
I think it's an appropriate question of impeachment, Your Honor. He's been talking about it, and we learned testimony yesterday that there was no gasoline engine on it.
Objection, foundation is misrepresenting the testimony. You're going to look at your notes.
I'm not sure he is, so I will overrule the objection.
Your question again was?
Sure. Would it surprise you to learn that there was never a gasoline engine on that boat?
I would have no way of knowing either way whether there wasn't or if there was.
And you've been doing fire investigations for about 52 years, is that right?
Let's see, 71, 29, 49, yes.
Yeah? All
Yes.
right. All right. And when you reach a conclusion in a fire case, okay, or a cause and origin determination, you're not making a legal conclusion, correct?
I know you've talked about legal, and a couple other things. It would be my conclusion based on all the facts and evidence, and I would turn it over to a prosecutor or something, yes.
Very good. That's your opinion, correct?
If I say it, it's based on more than just an opinion. Opinions anybody can have, and they're worthless sometimes. But no, if I say the fire is an arson, that fire is an arson. There is no opinion about it. It's the facts that are in evidence that prove that.
But someone could disagree with you on your conclusion, correct?
And one of us would be wrong.
Could be
In
you.
this case, it wouldn't be me.
Well, it could be you though, correct?
No, because I have the evidence to substantiate my position.
I'm not asking about this case, and we were talking in
No, I'm not
generality.
talking about this case either.
Okay, all right.
I thought we were talking
So-
about generality.
Sorry.
Yes,
Okay,
if you
thank you.
wouldn't mind not cutting the witness off.
I can't believe he just said that.
So you're saying your conclusions are always right?
No, I make a lot of mistakes. The main mistake I make is that when I have 95% that I think it's an arson, I don't have that other 5%. I'm wrong because I call it undetermined, but that's the only proper thing to do.
You've been involved in criminal prosecutions before?
Many.
You've been involved in other fire criminal cases, even not as with the prosecution, correct?
Yes.
And there's been situations where you've determined a fire to be undetermined, but that did not stop a prosecution for arson, did it?
There was no case I've ever, oh, I'm sorry.
The objection is foundation.
Foundation, you go ahead, I'll wait.
Yeah, I'll overrule that.
Okay. I've never been involved in a case where I said a fire was undetermined and it went to a court hearing, particularly in a criminal case. No.
You were retained as an expert in the People versus Clint Dunning, correct, sir?
I was.
And you determined that fire to be undetermined, correct?
I was trying to say more than that, but as the judge knows, I was ruled I couldn't say that, and there was no Daubert hearing or anything. But anyhow, it was an undetermined fire, yes, and I don't believe it was.
And yet, Mr. Dunning was still prosecuted and convicted of an arson-related fire. Isn't that correct, sir?
Objection, Your Honor. He wasn't on the side of the prosecution. He's mixing apples and oranges here.
No, I'm not.
Yeah,
Yes, absolutely.
I'm going to allow the prosecution question, but not the conviction question. I don't see the relevance to what some other jury on another case did to our case.
Well, I guess what I'm trying to get at is, because that was a response directly to his question of he's never been involved in a case where he was made it undetermined and then the person got prosecuted. Well, I think,
So you can ask about prosecution, but not about what a jury did.
And if he limits it to where he was on the prosecution side, that's different than if you're the defendant.
I'll
What?
allow you to ask about the prosecution question, but not
Fair,
what the
fair.
jury did.
so the bottom line is, Mr. Dunning was still prosecuted, correct?
He was prosecuted without an adequate defense, and he will be tried again, or he will be exonerated sometime in the future.
And that's your opinion, correct?
That would be my opinion.
You're not a
I
lawyer,
can't-
correct, sir?
No, that would be my opinion. I can't say that that's going to happen. I believe it will, that's all. But you're right.
That is your subjective belief, correct?
That would be true.
No further questions.
These last couple of questions, sir, that you were asked, you were testifying for the defendant.
Yes,
You've never been involved in a case, you were in law enforcement for a long time, right?
yes,
And you've never been involved in a single case where you were the fire investigator, where you testified or had an opinion that it was undetermined, where there was ever a prosecution. Is that what you're telling us?
that's correct.
Because if there's no intentionally set fire, incendiary fire, there's no crime.
Objection, Your Honor. You can't, that's a legal opinion.
Yeah, that's argument. I'll sustain the objection.
Then you were asked questions about the gas can. You remember that? This
That's a
red
lot of
gas
questions,
can,
yes.
a lot of questions. And what you would have done, you don't fault Mr. Leroy for taking it, right?
Correct.
The next day, the day after the fire, right?
Yeah, it was a day later, but he said, I think on the stand, he didn't see it the first time, so
Would
you
you,
wouldn't take it if you didn't see it.
would you have done something more than he did? Would you have done something like check for fingerprints?
Probably not, because on those
A
cans,
gas can.
it's almost impossible ever to get a fingerprint off those cans. They're
Remember,
not smooth.
remember the questions you were asked about the scientific method, and could different experts look at things, same data, same evidence, and come up with different conclusions? You remember that?
Yes,
The point of the scientific method is that you have reliability and reproducibility, isn't it?
yes.
Okay. So if somebody does a thorough, proper investigation, another expert looks at it, like a peer review, what should be the outcome?
That peer review should confirm whatever the first person did.
If it's done properly,
And if you have all the, the information that the first person had, yes.
like collected the data, the evidence.
Right, if the data isn't collected that you don't determine to be of any value, somebody else can't look at it and see if it was or wasn't of any value.
So under the scientific method, if it's done properly, you should come to the same conclusions. You would only come to a different conclusion if what?
If you didn't have the same data that was preserved, even if two investigators came to the scene at the same time.
I'm just talking about just a situation like this,
Oh,
where
yeah.
you don't get a chance. All you have is what the person did before you.
Yes, I or no one else would have had a chance to have the same information and data that Special Sergeant Leroy would have had.
So if it's done improperly, you might not come to the same conclusion. You come to a different conclusion.
Improperly or inadequately.
Okay.
Back to that word.
That ties in. Let's talk about adequacy. First things you were asked had to do with the definition of an adequate excavation. Remember that?
Yes, yes.
Does adequate mean middle of the road?
No, I think adequate to me, and I didn't look it up in the dictionary. I would have if I had time when I had a dictionary. I mean, it means enough. Adequate means enough. Whatever that enough may mean, it means it's what you need.
It certainly doesn't mean average.
No,
In your opinion, was there any excavation that Mr. Leroy did that could be deemed adequate by any standard in your field?
well, if Mr. Leroy said he removed all the evidence, I saw that.
This is a witch hunt. I don't like this
He
at all.
believes, but not the entire field. I don't think he can speak for every cause and origin expert on basically yours.
You could
He's-
limit the question.
I'll limit the question. You're certified by AIIA,
Yes,
the NAIA.
yes,
You've taught for years.
yes,
You trained for years.
yes.
Is there any, in your experience, any type of organization that would suggest that what Mr. Leroy did with his excavation was adequate?
Objection, Your Honor. He can't speak for every organization. He can speak for himself.
I'll sustain the
Okay.
objection.
In your opinion, sir, did Mr. Leroy do anything close to an adequate investigation?
Anything close is very vague. I would say that NFPA 921, there's a photograph and some things you need to do, particularly in a fatal fire, about sifting debris. There was a grid search I think we talk about, it depends, you know.
Well, let me ask you this, sir. He
Let him
testified
finish
he
his
cleared the
answer.
floor, 18 by 18. You remember that?
Yes,
Did you see any evidence that he did that?
I saw a space of maybe, I can't really tell you dimensions, 4 by 6 toward the fireplace that was cleared. And I saw other debris outside. But going back to my Laird's talk, because we have collapse of roof and flooring and everything, you'd have to get down to the floor, but he said he did it to the floor.
Did you see evidence that he cleared an 18-foot by 18-foot by 2-foot area of rubble, sir?
I did not.
Did you see any evidence of a 7-foot pile of rubble, 4 feet by 8 feet by 7 feet, that he said he did?
The cubic foot thing, how much we had for 18 by 18 by 2 or 3, if it comes to that, 7-foot pile, no, I didn't see anything like that.
Now, you were asked a lot of questions about area of origin and the size of origin. NFPA 921 guides us on that, doesn't it?
Yes,
Ideally, you'd like to find a point of origin, am I right?
that's the goal.
And what happens as you get larger and larger and larger areas of origin? What happens to the reliability of your opinions?
The larger it is, and you can't confine it to something smaller, how can you actually say what occurred if you have that big of an area of origin? To say this is what the origin was and this was the cause.
I want to go back to Mr. Shinsky's photograph when you talked about, let's see if I can get this now. Mr. Shinsky's, oh, that's what it is. Photograph regarding the back of the house. Thank you, Ms. Heidi. I think that's it. Okay. Getting back to Mr. Shinsky's photograph of the house, you were given a lot of questions about the chimney chase, remember?
Yes,
Based on your review of the records, drawings, everything, how high was that chimney chase?
it would have to be higher than the peak of what was covering that, those 2, 4, 6, 8 bay windows.
Okay. And these bay windows in the back of the house, what can you tell us about what would have happened to them if there was a fire in the living room?
If the fire was in the living room and originated in the living room, the fire takes the path of least resistance. It doesn't seek or look for or anything like that. It's an inanimate object, but it will take the path of least resistance. And with that in mind, those windows are going to be compromised and the flames are going to come out where that oxygen is coming in. And if it started there, all of that should be burned away. That shouldn't be standing there anymore.
Because fire goes up.
Yes.
And also, if we're talking about, you said there was OSB board, the testimony has been a lot of wood, open wood in the house and around the chimney chase, OSB board.
Yes.
If that is up there, and we're talking about 2 stories, how is it going to fall into the living room?
Well, again, where it actually started, which none of us know, where that fault, if that's what the cause was. We don't know the level of that height where it was, but if it was still in the confines of the cathedral ceiling, it would fall inside the living room. If it was above that, it's going to fail and fall on the roof basically and cause a fire up there.
And you're not here to tell this jury definitively, based on everything you could find, that the chimney chase is the area of origin, are you?
Correct. No, I'm not saying that's what happened. I'm saying that was a very strong possibility, but I could not say it was.
And it's a strong possibility that has to be ruled out by the fire investigator?
Yes.
And did he?
No. Well, he ruled it out, but he didn't have evidence to rule it out.
Okay.
Okay.
All right. So under the scientific method, what you folks always use, you have to rule out these alternate probabilities, possibilities, right?
Right. You have to be able to disprove everything else except your final hypotheses.
Right. Now, let me ask you about possibilities. Since Mr. Blair asked you about, is it possible somebody could pour gas on somebody in the living room and then run down the stairs? Remember that?
I do.
Experts, do you deal in possibilities?
No, that's so much of guesswork that it doesn't apply to anything as far as science goes.
You deal in evidence and probabilities?
Probabilities, yes.
Okay. Then you were also asked, well, why didn't you use a human being for those sweat pant tests or an animal? You remember that?
I do.
And why didn't you use a human being for a sweatpants test or an animal like a pig or whatever else he said?
There's this anthropologist doctor in California, and I wanted to set up, because she burns bodies and for a variety of reasons, but she's an anthropologist, so she burns them too much. And I wanted her to do an experiment for this, and she would, but she was already tied up to doing all these burns for an anthropologist, like bones. They were down to nothing. So I tried to get a cadaver somewhere else. All those things failed, so I couldn't do that. But the mere fact that I know what's going to happen to a body when you pour gasoline on anything.
Objection, Your Honor, he's testifying things this court's already ruled.
Yeah, Your Honor, please, there's a legal objection in here somewhere.
It's irrelevant.
There,
It's outside the scope of
Oh my God.
thank you. Why didn't you use a live body like Mr. Blair suggested?
Jerk.
The live body would have gotten hurt or killed.
And it's unethical?
That would be a good reason, yeah.
Now you're testifying.
Oh, you were also asked about some questions about polyester and difference in polyester. First of all, you understand, you do understand polyester is a man-made synthetic
It is,
plastic.
yes,
So it doesn't matter what kind of little blend of polyester it is.
correct,
Polyester melts.
yes,
And that's what you're trying to illustrate in that video.
yes.
Okay. Give me 1 second, Your Honor. I think I might be finished.
Good. Oh,
You're aware that Mr. Shinsky has a lot of expertise in fire investigation, origin, and cause,
Yes,
as do you.
yes.
Are you aware of any expert in this case, other than Mr. Leroy, who said that what Mr. Leroy did was adequate?
Object, Your Honor, that's one for hearsay.
If he's aware, I didn't ask for a statement.
I don't understand the question, honestly. What
Are
is
you
it?
aware of any evidence that any expert in this case besides Mr. Leroy defended what Mr. Leroy did?
I'm not aware of any evidence.
What was your answer?
I'm not aware of any evidence to that.
Thank you.
Thank you. Mr. Blair?
You would agree with me, sir, that that cause and origin investigation is not a, like, quote unquote, hard science. Would you agree with me there?
What do you mean by hard?
Well, that's a bad question. Let me rephrase that. Like, for instance, a chemist in a lab or a DNA expert working in a forensics lab that rely on very controlled environments, scientific instruments, et cetera.
Yes,
So you would agree with me that that cause and origin is not a hard science?
there are variables that
I
are
don't know.
uncontrollable, yes.
Because a lot of this relies on your training and experience, correct?
That
Correct.
comment was
And
uncalled
it's
for.
your interpretation of fire patterns. Is that correct?
The judge is not supposed to reprimand the attorney in front of the jury like Bev Canoni did to Jackson all the time. You know that's not appropriate, Mr. Jackson. You're not supposed to make comments like that. That's not appropriate. But she should have called them up to the bench, both of them, and said, tone it down. You shouldn't be saying things like that. I don't know why she's letting this go on. Same thing in the Hannah Gutierrez Reed trial, in the Russ trial. That judge said, no, you're not doing this in open court in front of everybody. Come to the bench. And that's what this judge, she needs to grow a pair. I'm telling you, she's too meek and mild. I mean, her rulings are good, but she's not controlling her courtroom well.
Fire patterns are being more and more discounted unless you have them covered with gasoline or some accelerant well, it depends what patterns you're talking about. I misspoke.
That's okay. That's all right. I'm asking in very general sense. It's you looking at something and then evaluating it based on your training and experience, correct?
Correct.
It's not something that you bring out a special instrument and it measures it and it gives you
I don't know.
a answer within a reasonable degree of scientific certainty, correct?
No, we don't have that yet.
I have no idea.
All right. Would you agree with me that a person that would have the opportunity to go to the scene and view the scene in its original condition would have kind of a better idea of what went on?
I guess I have to use
Objection foundation and call from the speculator, we're talking about would have a better opportunity, that'd be one thing.
Overrule the objection.
it depends is what I was going to say, and then I will explain it depends. It depends on the level of experience of the one person as opposed to another. And it more depends on the first person preserving the evidence for someone else to see.
You would agree that being able to view something with your eyes in person is better than looking at photographs, correct?
Absolutely, but that can't be done in fire investigations because you're moving debris and changing the aspects of the scene as a way to get to the cause of the fire, and that's why you have to document it.
And just one final question, and just so we have a foundation here, you again reviewed Linda Stermer's statements, correct?
During the course of my 12 years involved in this, yes.
And you reviewed her statement that she stated that the only place she saw fire was between Todd's recliner and the master bedroom, correct?
I guess the word between again means it wasn't on either one of those things. It was between them. But if you want to say the expanse of the fire, yes.
In other words, she observed a trail of fire between the master bedroom and the living room and the recliner,
Quit
correct?
shaking your
I
head.
believe I answered that a long time ago, saying a trail is a whole different subject and a whole different observance or perception of a fire that is burning in all of those locations. There's nothing to do with it. Trail.
Nothing further, Your Honor.
Mr. Shinsky's experience, even Mr. Leroy's experience, very hard to fool somebody like you into thinking that a intentional fire
I don't
is
know her
an
name.
accidental fire, right?
Objection, Your Honor,
Can
from the
Google
question.
I'll sustain it.
There are obvious
Speculation.
signs when some,
You're
I
welcome. Thank you.
apologize.
It's sustained.
Thank you. There are obvious signs when somebody is trying to intentionally start a fire, right?
Objection, Your Honor, calls for, well, it's a very broad answer, it calls for speculation.
He's got 50 years.
The way it's phrased, I'll sustain on speculation.
Okay. Can you tell us the kind of, you mentioned trailers. Explain for the judge what a trailer is.
A
Not
trailer
for the
would-
jury.
Yes, observing a trailer. There was more of that years ago than there are now, but people would pour gasoline. I think that Mr. Blair actually said, you know, if you walked in this room and somebody poured a trail and set it on fire, you would very clearly see it visually if the fire flashed and went out. I think I remember Mr. Leroy was asked about a flash fire before too. And it's very obvious to see, and you'll smell the gasoline and you'll see this pattern. But it doesn't conform to the question I was asked and what Ms. Stermer saw.
Okay. A trailer would be obvious as opposed to should there was gas within a boundary.
Well, trailer can also,
I mean, strike that, not gas, fire within a boundary versus a trailer.
right, exactly. And a trailer is a whole different meaning by me in all the years and way before 921. It clearly shows whether it was more masked by a flashover or whatever the case may be. The whole room may be involved, but hypothetically and sometimes often, when you go through the debris, you will find this pattern, which is called a trailer. But the question I've been asking is not anything to do with a trail or a trailer.
There were no evidence of a trailer in this case, was there?
No,
No evidence of multiple points of origin in this case,
no,
which is another sign
yes,
that might suggest arson.
yes. If a fire was over here in this corner and a fire over in that corner with no reason for either one of them to happen, and they weren't communicated one to another, be clear to all of us that that was something wrong.
Okay. And then finally, your ability to determine whether somebody did a job properly is based, one, on, you said, their competence and experience,
Yes,
and also would it be based on their candor and truthfulness in what they did?
yes. I always liken fire investigation to a chef. You're only as good as your last meal. Wolfgang Puck may have made a million good meals, and as Mr. Leroy, but this case wasn't sufficient, wasn't done sufficiently.
I don't have anything else. Thank you.
Obviously, in this case, we can't verify any trailer or anything in the living room because it was completely destroyed, correct?
The floor was, yeah, it was OSB. It went down below. Whatever was below, you might find the remnants of a ignitable liquid, but you wouldn't find the trailer, correct?
Well, there is certain factors that can determine whether or not you're going to find an ignitable liquid, correct?
Yeah, it depends on the degree of damage.
Right. So if the floor was completely destroyed and burned away, that could be a factor, correct?
Well, when you say it was completely burned away, there's residual debris on the floor. Yes, a lot of it was consumed and fell. The condition of how much was left is something I'll never know.
And another factor that could affect gasoline would actually be the amount of water used by a fire department, correct?
Gasoline is not water soluble. I've had cases where, well, I've actually did demonstrations where I could put 1,000 gallons of water on 3 ounces of gasoline on the ground, and the gasoline would stay on top, just like when you have oil slicks or slicks like that with petroleum distillate. They're going to remain there and the water is going to go past it. It could push it around, but it's not going to change its components.
Well, that's my point. What you just described sounds like a controlled experiment where it was on a standing body of water, correct?
No, I'm saying that I poured the gasoline, and I found gasoline when 500,000 gallons of water had been applied to a fire scene, and still found residue of gasoline that was analyzed in the laboratory. What I'm saying my demonstration is that I poured a minuscule amount of gasoline on the ground, and then didn't direct stream that thing so it would be spread around. It was not lightly put on. It was a fog spray. It wasn't fog, but it's just wide little pellets like when you're in your shower. And then we let it sit for a while and wet and still get the gasoline. But I'm saying in the real world, I've done that also. You know, we know sometimes that there had to be something to accelerate a fire based on witness information, based on what we could see physically. And we have come up with a gasoline sample after going through all the debris.
Sometimes you don't, correct?
Sometimes you don't, correct.
And you would agree with me, obviously, that a fire hose is different pressure and different volume of water than that of your hose you use in your experiment, correct?
No, I used fire hose.
Oh, you used a fire hose.
Maybe I was first off, I had a fire truck of my own,
Mhm.
but that was done, I believe, in Detroit. We did it with a bigger truck. I had a mini pumper.
That was not in a burned out house, correct?
No, but I have had the same experiences in a burned out house. And by the way, I can tell you the pressure, if you want to let me, it's usually 200 pounds per square inch is what we fight fires with. Can vary a little bit here and there, but it's a lot of pressure.
Thank you.
Yeah, just finally, whether you can find any remnants of gasoline depends on how good you do your excavation and how thorough it is.
Certainly we'd be part of it.
Okay. And any evidence you have of evidence samples for gasoline that Mr. Leroy took, there was no evidence of gasoline, right?
We didn't take any sample.
Okay, thank you.
Jury, do you have questions of this witness? Okay, I see some coming in.
Mike. Yeah, I don't think I've had an issue with any of her rulings at all. It's that's not the problem. She just lets the lawyers do whatever they want. And the woman lawyer has not been out of line. And the male prosecutor hasn't until he's starting to get that way, but that's out of frustration with the defense. Yeah, she needs to set an example. But I've not had a problem with any of her rulings. Her rulings have been great. You don't like these, Spike? Remember you tried them. Because Aunt Judy told me that you said you liked them. Because she always takes your side about everything. Should I tell her that you pooped in the floor again? He went, Your daddy shampooed the carpet last weekend. It was nice having a clean carpet. And I was going to have to shampoo it again this weekend. What, you going to hide under the desk now? I wouldn't even know what to ask because his testimony was so rambling and telling stories about other fires. Your Aunt Judy said you were framed. Did the yard monster come inside and poop in the house? I don't know why he doesn't go outside anymore. The only thing I can think is the neighbor's wild pack of dogs that I don't even think he feeds anymore has scared him to the point that he doesn't want, because that's when they're most vulnerable, right? So I don't think he wants to poop outside because he's afraid that wild dogs are going to come up while he's pooping. I don't know. But after they killed the cat next door, I don't blame him. But I also can't call animal control on the guy because the county bends over backwards for that man. And I don't know why. They won't do anything. If it happens, if they come in the yard when I'm outside with the dogs and anything happens and I have to shoo them off again, I'm just going to call animal control and be anonymous. And, well, I guess I can't be anonymous, but I can say there's wild dogs in my yard. I have a friend that used to work for animal control. She used to get calls on him all the time, and they never would do anything because her boss was friends with him. And I called her. I'm like, the other day I called her. I'm like, what do I do? And she goes, shoot him. I was like, what? She goes, yeah. Just make sure that they're on your property when you do it. Travis says, well, you didn't go outside with him. I said, I can't. I'm busy. I can't. If I leave the computer, StreamYard will crash. I can't. I can't stay outside with him the whole time. I may not get paid much, but y'all are paying me to be here now. So I'm at work. I wanted to get one of those like outdoor kennels, like the big caged in area. I mean, it's like a cage, but it's huge, to put in the backyard. But Travis says no, because then we'll have to clean up the poop. It's like, so I'd rather do that than them poop in the house. We still have to clean up the poop in the house. I'd rather them do that outside than have to clean it up. Knowing him, he'd just sit in there and cry though, because he wants out. He's such a baby dog. Oh, shoot. Thank you, Judy. I didn't realize it was paused. Long.
From the jury, sir. Are NFPA guidelines interpreted subjectively or absolutely?
Well, as I said, NFP guidelines total? I'm sorry.
It just says, are NFPA guidelines interpreted subjectively or absolutely?
Depends. Some are absolute and some, are, they can't be
Depends with
used as a standard or a, doctrine of how you do things. But I think they're probably referring to 921, don't you think, or not? Does it say?
Yeah, it just says NFPA guidelines. My guess is the 921.
Yeah. So no, 921 is a guide, but it is a guide that is supposed to be a subjective, not a subjective, an objective document that you take, because it talks about don't be subjected a lot of the areas. I think some we put on the screen. So, but it's not an absolute, it's not something you must do, but if you don't follow it, I can tell you that it won't be good for you in the end.
If you could
How does it
answer
make
this one with a yes or no, please.
Okay.
Do you have any personal connection with Linda Stermer or her family?
I do not.
Do you conduct all investigations remotely? If not, why?
Almost never remotely. I'm almost always at the scene conducting an investigation like Mr. Leroy does. Not too many other ways of doing it other than if you're going to be trying to assess somebody else's work.
Where was the electrical panel installed in the house?
Basement level along the south wall.
According to NFPA 921 regarding excavation and debris examination, the terms adequate, in quotes, and some, in quotes, were shown. Does the investigator determine what these terms include?
I'm not sure about the word some. I'd have to, see that paper again. But there's a lot of, an investigator is given some latitude about what he feels is necessary. But if you're going to make a definitive adequate level to make sure that your determination is correct.
Thank you. In Leroy's photo of the rear of the house that you reviewed, more of the exterior is burned away on the north side of the bay window than the south side. If the fire started in the chimney chase, why would you get an asymmetrical burn pattern on the window area?
There's only one picture I think that was shown. I don't know Mr. Leroy's, I don't think he showed any other ones, but the dash cam from the sheriff's department, first arriving sheriff, You can see that the wind was coming out of the southwest, going across the house to the northeast. That's the explanation. Well, ventilation and fire suppression also.
How common is it for you to be called to review a case done by someone who was an expert in their field?
Common's kind of a common word. I guess if I took percentages of how many fires I do and do somebody else's, do a technical review as opposed to my own, it would be slight.
Having not been to the house yourself right after the fire, did you at any point talk with Mr. Leroy to review any part of his investigation, to ask why or how he came to any conclusions? If not, why not?
Okay, I relied on his report and other information that he gathered. Normally speaking, we don't communicate, although we had the federal evidentiary hearing, we may have spoken a little bit, but it really wouldn't have been getting into the meat of the matter of the fire. It would be what he reported and what he testified to and what I testified to.
You stated there are 2 editions of NFPA 921, one published in 1992 and one in 2024. Are there procedures and codes in the 2024 edition that are not in the 1992 edition?
I wish I'd have brought both of them in. They're in my car. The 921 today is this thick. The 921 in 1992 was 1/5 of the dimension of this book, but I didn't mean to confuse you. These are not the only 2. They're published and printed almost every 3 years. The first one in 92, then there was one in 95, 98, 2001, 2005, then 2008, then 2011, 2014, 17, 21, and then this book. Each one of them, became more refined, had more information for us to have a better knowledge base. A lot of the book really doesn't have a direct relationship to what Mr. Leroy and I do, but it's something we should know about and how to proceed from there. More about electrical and mechanical, and they've added more about wildland fires, but watercraft, I guess, put it that way.
Okay, so there are some differences?
Yes.
Okay.
Yes.
And which edition are you quoting from today in regards to fire investigation, procedure, and regulations?
Everything is from the 2024 version because it's not a standard. If it was a standard or a code, you would rely on the code or standard of that. Well, by the volume, you can see it's ever changing or ever more additions. And today, I need to be testifying to what was in 2024.
Is the 2020 relevant to analyze information, data collection, and excavation from 2007?
Yes, it expands upon it. And what was done in 2007 might not have all of the different things that need to be done now, but we are now in time frame. And if I may have testified to less than this book naturally, because there wasn't this big book in 2007, but I would be responsible for what happened in the interim, how much more knowledge we have, our knowledge base is greater. So I would have to testify to what we have now, even critiquing my own investigation from 2007.
If you believe the fire may have started in the fireplace chase, then how do you explain how the fire made it to the victim recliner in the manner depicted by defendant?
If the chase is compromised and there was no barrier between the chase and the living room, there could have been a great deal of falling debris coming down on top of him. His hands were burned like this, as though he was stopping himself from whatever was happening.
He can't testify to the position of the.
I'll sustain as to the
Okay.
position of him. We'll move on to the next question. How do you explain the victim burns on body, but sweatpants seem unharmed?
Okay, that's a pretty easy one for me, but
Just answer.
your
the
body
question.
can only take temperatures from 110 degrees Fahrenheit and up. Pants, clothing items, I don't know if any of you have heard of them. There's 2 movies, 1 remake, Fahrenheit 451. That is the basic lowest temperature that combustible clothing materials and other materials will actually ignite. So well, I can't get into that. That's the reason, is he's not burned. I mean, the pants aren't burned. He's burned because he could only take the 110, and he could only take it for a short time. I would say that because of convected and radiated heat transfer, I'll give you another example. The sun is radiated heat. If we stay too long in the sun, our clothes won't burn, but we will. You know, we're going to feel that heat, especially when it's exposed, but even if it's protected by the clothing. But that was one of the big reasons why there was no way, well, can't get into that.
Okay.
That we can leave it at that. Skin and body
Let's leave it
burn
at
much
that.
quicker or get
Shut
degraded because of a lower temperature exposure.
Thank you. Council, any questions in light of the jury questions and answers, Mr. Blair or Mr. Mueller?
Yes, thank you. Probably gonna go backwards because it's freshest in my mind. This idea of skin burning, but the clothes didn't burn. Does NFPA 921 speak to that?
They do, or it does.
Do you have a section on that you can tell us about?
Not sure if I have that section marked anymore. I might have taken it out, but I'll find it.
I don't care.
How about
I am so
section
tired of all the
24.2.5
editorializing. I'm getting a headache.
And 24.2.5.1. How about we go there?
Okay, I do need glasses, I think.
You want my pair?
Seven looked like a 5 or something to me. Yeah, it's on the top of the page. Yes. I got it.
22.4, all right, 24.2.5.
24.2.5, yes.
All right, what does that tell us skin burns at? Thermal burns begin.
Wasn't the section I thought it was going to, but let me see. Maybe need better luck. This
That
talks
section,
about,
does that section, do we have a section that tells us thermal burns begin at 110 degrees?
we do, but I don't see it here. This is more about kilowatts and.
I might have the wrong section, but you do know what NFPA 921 talks about
It's
skin
in,
burns.
it's in the book. Let me, it should be in this section, I think.
Do you remember what Dr. Markey said the burns, how he described the burns as thermal burns?
Yes,
And then this NFPA 921 also tell us that heat can be transferred through clothing, causing burns to the underlying skin without any readily identifiable damage to the clothing.
Yes, well, I've seen that firsthand many times.
And why is that?
Because of the ignition temperature, the temperature of burning for the clothing materials at 450-degree level, as opposed to your skin at 110 and a shortly small amount above.
There's a picture that's up on the screen. I think it was addressing a question about some damage more to the north side of these bay windows, which would be the left,
Yes,
right? And then you mentioned a photograph from the in-car video.
yes,
Does that show the wind blowing toward the north?
yes.
Okay. Would that help account for the fact that you may have more damage to the north side?
Absolutely.
That question
And
was
with regard to 21 changes about every 3 years?
Yes,
It's
it's
updated.
supposed to be consistent every 3 years. I can tell you that I was on technical committees, and I'm not on now. I get no more time. But hopefully I have a lot more time, and it means that way. Anything else that's new and advanced, and then there's
that question about the wind. That was pure ego. He asked that because the jury asked it, and he didn't even think to ask it.
technical committee, like the judge takes these things and looks at them, and then if they're valid, or I'm going to say any of your questions are invalid, but questions that really make an impact for a newer section in the book or even a sentence, that will be put in, and then it's voted on by all any NFPA members at the end.
Mr. Trinkle, some questions addressed 2007's version and what might have been in effect then versus 2024. We are here in a 2025 trial. You as an expert, and any expert has to be open to change, right?
Absolutely.
So what standard or what guidelines NFPA 921 apply to this trial and this criminal case in 2025?
That would be the 2024 edition.
Most of his questions are leading.
And just with respect to the various guides, if you're not open to change, what is that evidence of?
Can't be stagnant. You always got to be moving forward and learning every day. I learn something every day. Sometimes it's irrelevant, but like stepping on a Lego coming out of my bed.
Oh, I have a question.
Yes.
There was a question regarding are some of the guidelines absolute or subjective? Remember that?
Yes.
The scientific method has been in effect since 1992 and before.
Yes.
Right? That has to be complied with.
Well, the caveat is it has to be utilized and complied with unless you can absolutely say you did something equivalent and it comes out to the same thing, just trying to get to what caused the fire. But normally speaking, if you said you didn't do this, they wouldn't even allow you to testify in most courts.
Certainly, Mr. Leroy was subject to scientific method in 2007, just as he is today, just as you are.
Yes.
And you have an opinion, you said, as to whether he complied or not with the scientific method, and that was?
No.
Okay. And the excavation principles in NFPA 921 are the same now as they were back way before 2007, right?
Yes.
So the fact that he didn't do what he told the jury he did, that would be in effect, you're held to those same standards.
Yes, you are.
Are there any other questions? Thank you, Mr. Trinkle. Let me get my,
Yeah. Thank you.
You, I think you've even testified that to this here in court today. You don't agree with all portions of NFPA 921, correct?
Some I get revised and people like Mr. Leroy and myself would look at them and ask, put a suggestion like the jury, the jury box to make a change. I've had sometimes where the computer section was new and the second edition that came out, I think it's 2005 and 2008, one of them said this is, and it was wrong. It was typo, but a big typo. And so then they put in now is not. They left them both in.
Well, but I think you've even testified this here in court. You don't agree with some of the information or the way they define things in NFPA 921, correct?
I guess define, you have to explain what definitions you're talking about.
I think we talked about you used ignitable liquid.
Oh, yes, I don't like that, yes.
You don't like that,
I
correct?
do not, because I have to explain to a jury that liquid doesn't ignite. It takes me more time to get to the point of fact.
And NFPA 921 is not an absolute, correct?
Correct.
It is, there's no requirement that you follow it, correct?
Requirements.
Legal requirement.
I guess there is no legal requirement.
And I think you testified to this in 2007, there were less requirements or less guidance, I think, in the 2007 edition than there was in the current editions of NFPA.
Yes, the 2007 would be somewhere halfway between these two. Each volume from the 92 version, which was very thin, the 2007 version increased in size and what was covered. And as I say, every year, every edition, I've never seen it get smaller.
So I guess at the time in 2007, a fire investigator would have only had the guidance that the 2007 edition would have been providing, correct?
That guidance from the book, yes.
And would have only had then that guidance when conducting their investigation, writing their reports, so on and so forth, correct?
Right. We don't carry the book with us.
Because you would agree with me that looking back at something from today's standards to 2007, that's kind of reviewing something in hindsight, correct?
Yes, but like I said, I would review my own now and probably criticize it in a critique of what I didn't do the times before, but it wouldn't be critical.
But at the time, it may have been completely appropriate.
Completely appropriate. I'd have to know what you're talking about. It
Well,
was
sure.
a particular thing.
Well, you were just talking about looking back and even second guessing yourself or reviewing yourself, right?
Sure.
So, but what I guess what I'm getting at then is if you're looking back and finding things you may have done wrong in, 15 years ago, it didn't make them wrong at the time, correct?
It all depends what you did wrong. If you called a fire something that you couldn't prove, and now you find out that you can prove it or disprove it, as you mentioned before, yeah, those are variables I can't really address.
Now, when a fire goes up, it actually hits a roof and spreads out, does it not?
It hits, let's take this room, for example. Yes, fire starts on the floor level, continues to burn upward and outward, depending on the configuration of the room, configuration of the fire load, but eventually it hits a barrier like a horizontal surface, then it spreads out.
So, for instance, in the pictures we've looked at then, I think this is based on one of the juror questions, if the fire had gone up, it should have hit the roof and then spread to all areas of the roof in the Stermer residence, correct?
Way beyond what is the questions from the jury.
I think that's right in line with the juror question.
Oh, I'll let you ask, but I'll alert both of you. This witness has been on the stand since yesterday, so if you have any great questions, I'd suggest that you ask them now.
I think that's right in line. I'm sorry.
Thank you.
Could you please rephrase? I don't want to
Sure.
say something wrong.
If the fire had gone straight up and hit the roof and then spread out, like you've talked about what they do, it should have spread to all areas of the roof in the Stermer house, correct?
I don't think it's going to hit the roof. It's going to hit the ceiling of the cathedral ceiling, which isn't the roof. It's not right there. You've got
That's what he
probably
meant.
scissor trusses or something to separate the ceiling of the cathedral ceiling from the roof. And it's going to spread from there first. And it's going to, as I said, heat and smoke, fire, rise, but they rise in a conical shape. It's not like this is three-dimensional stuff. Wherever the fire starts, say where Mr. Leroy is sitting, it's going to go in all directions around him and up until it meets that resistance. But that resistance is part of the house, not the roof.
Just a moment, Your Honor. Questions, Your Honor? Thank you.
I think you limited it to great questions.
Yeah, brief, great
Oh.
questions.
You were just asking questions about
Good.
complying excavation documentation. Those were absolutely
I'm part of this
required in
camp.
2007, just as they are now, right?
That's correct.
And that is ingrained in fire experts from the time they start training, right?
Yes.
You remember, you were asked questions about, I'm going to call it, I forgot what Mr. Blair called it, playing devil's advocate with yourself. How could I be wrong?
Yes.
Right? And that's something that every fire investigator should do throughout their investigation.
Yes.
Do you have any evidence that Mr. Leroy played devil's advocate with himself on any part of his
Your Honor,
report?
that calls for speculation.
Do you have
Sustained speculation.
Okay. Is there a requirement in 921, back in 2007 and now, to be truthful and candid in your documents and reporting?
I'm going to object, Your Honor. I think that exceeds the scope of these jury
I'll
questions.
sustain cumulative.
I don't have any other questions. Thank
Did
you.
he just object on the grounds that the jury didn't ask that?
May this witness be excused from
God,
subpoena if he's
yes.
under one?
No
Counsel?
objection.
Yes, I don't think he's under.
Okay, thank you, sir. You're all done. You want me to take this trash to discard? Yes. I can do that.
I agree.
Oh, is this the gray the sweatpants that have been admitted?
That's an exhibit.
Oh, okay. What, was that admitted? Oh, okay.
No, that's my,
Was that admitted? No.
no, that's my,
Okay.
I just referred into
Okay.
it.
So, Mr. Mueller, Mr. Kelly, any other witnesses?
I don't know.
Any other witnesses? Okay. You
I'm
may call your next
confused
witness.
about what was finished and what was not, because some people say it was almost finished and other people say it still had a lot more stuff to do. So I don't know. Some people said that the windows were all framed and some people say they weren't. So some
you
people
confirm?
say there was flooring and some people say there wasn't. I don't know.
If you pause briefly. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Thank you. Please have a seat. And once you're settled in, we'll have you tell us your full name and spell the last, please.
My name is Mariusz Ziejewski, Ziejewski.
Thank you.
I'm not even going to try this one.
Sir, can you tell us what you do for a profession?
I am university professor at North Dakota State University.
And what is your specialty, or what do you specialize in?
My specialty is impact biomechanics.
What is that?
God.
Well, that's application of physics, engineering principles in the study of forces on human body and effect of those forces on human body.
Okay. Can you give us an idea of the education you have that brings you to court today?
Well, my my highest scientific academic degree is PhD, doctorate degree in engineering from North Dakota State University. I graduated in 1985. I have 2 Bachelor of Science degrees and 1 master's degree. All those degrees are from my native country, Poland. One of my Bachelor's of Science degrees are in mechanical engineering, and I'm diplomat engineer from Europe. It has equivalent standing to PE, professional engineer's license in this country. My Master of Science is in bioengineering or equivalent to bioengineering. My other BS degree is in life sciences. Then I became university professor in Poland and worked on my doctorate degree in Poland. And I was invited on a research exchange program between professors from Poland and the United States. And back in 1980, I came to North Dakota State University. I quit my doctorate degree in Poland and started at North Dakota State as a part of my research exchange program, and graduated in 1985, became 1 year lecturer, assistant professor, associate professor, tenure associate, full professor, and now I am professor emeritus.
Does that mean you're semi-retired?
Not really. I mean, I could, but no. But really means that it's a title. We can essentially do what we want to do. My choice is to continue work on the research. I have 2 PhD students. I don't teach.
What kind of research do you do, and how would it relate to injury causation that you're here for?
My research is in human brain modeling, mathematical modeling of human brain. In other words, how external forces affect human brain. I've been working on this project for the last 30 years. The primary sponsor for this project, research sponsor, was Department of Defense.
And specifically, who are you working with? What types of folks do you work with?
Well, it started in early 90s, National Highway Traffic Safety Administration. It is part of our government, civilian government, U.S. Department of Transportation. I worked from 1992 to 1996, 97 on mathematical modeling of human brain. NHTSA, for short, used this program that I developed in the study of real-life car crashes to understand the effect of head strike into the A-pillar. A-pillar is the connection between windshield and side window. 1996, I was invited to join Armstrong Aerospace Medical Research Laboratory. This laboratory is part of the United States Air Force. Yay! At the Wright-Patterson Air Force Base in Dayton, Ohio. Back then, in 1996, women received all the rights that men had. And the question was how the safety system of ejection seat perform for female. Body dynamics for female is different than for male. In the scope of this work that lasted about 15 years, I was involved in an analysis of 900 full-scale tests with male and female pilots. In 2007, now remember Afghanistan war, a lot of traumatic brain injury cases, and unfortunately, many of our soldiers were released to civilian life with a clean bill of health, and actually they had the brain injury. So Congress appropriated over $100 million to Department of Defense to study that issue. And I was fortunate enough to be invited as a scientific consultant into that endeavor. And part of that work, I had $1 million research grant. I chair a number of different committees that relate to biomechanics of traumatic brain injury.
You have taught not only in engineering school, but you've taught medical school. Tell us about that.
That's correct. I'm an adjunct associate professor at the medical neuroscience department, different university, 70 miles north from Fargo, University of North Dakota. I'm not a physician, so I don't teach medicine, but I teach how injury occur. So I was involved in teaching team-taught courses and obviously teaching the mechanism of trauma. In addition to it, I was involved in a research project, the School of Medicine and local emergency room. And the objective was to apply knowledge that we have in automotive field, in military field, to medicine, into emergency room. Completely different fields, and medical students do not know much about what we know in biomechanics. Obviously, we don't diagnose injury. We identify risk factors. We identify likelihood of type of injury. Physicians do what they're supposed to do, diagnose and treat injuries.
Can we kind of, put a bow around your background as injury mechanics, what causes injuries, the forces that are involved in injuries?
Yes, that's what it is.
You've lectured, I'm sure, before,
Yes.
around the world?
Well, yes. No, first of all, at North Dakota State University for 35 years, altogether as a professor for 40 years. But outside lectures, yes, at many different conferences throughout the world.
This is not the first time you've been in court in litigation, right?
That's correct.
Okay. You have been qualified as an expert in injury biomechanics. Give us an idea how many times.
I testified probably at least 80 trial cases since year 2000.
Around the country,
Yes,
federal and state courts?
yes.
Okay. Your Honor, at this point, I'd like to move for the admission of Dr. Chesky, I'm going to butcher it, CV, and for his admission as an expert witness in injury mechanics, biomechanics.
No objection, Your Honor.
I will receive his testimony as an expert in injury. You said injury biomechanics?
Thank you.
Okay.
Doctor, can you tell us, in this case, you and I got together a few years back, what was your assignment, if you understood it?
Well, I was asked really two questions. First question I was asked whether or not from biomechanical perspective, I can assess severity of trauma that this particular individual sustained. And the second question was whether or not we can determine how fast the vehicle, the Ford, was traveling
That's not
at
what
the
killed
time of the contact with the individual.
That's not what killed
Now,
him.
you weren't talking about burn injuries here. You were talking about I'm going to call them orthopedic injuries.
Right. I talk about blunt injuries. I don't talk about the terminal injuries.
It's blunt
What did you
force
review
injuries, not
to be able to arrive at your opinions, sir?
Well, the most important for me was the medical records, the autopsy records, the medical description of the injuries
This is
were the most
like-
important. I also had the information about the type of vehicle it was involved. I received photographs of the wounds and photographs of the vehicle with the blood on the carriage.
in the Todd Mullis case, I get it. In Karen Reed, I get it. But in this one, I don't get it. That's not what killed him. The fire killed him.
You reviewed the autopsy and medical records. I'd like to show you, prepared a PowerPoint. I don't know if you have it, but I'm just going to show you a slide from your PowerPoint. You can tell me if this helps illustrate your testimony.
Okay.
Is that a slide you prepared?
Yes, I did.
And what does it describe?
Essentially, it is verbatim statements from the autopsy record. As a biomechanical engineer, I'm historian as far as the injuries are concerned. I accept the injuries as diagnosed by physicians and present in medical records.
Okay. Does that help illustrate some of your testimony regarding Mr. Stermer's trauma injuries, forced trauma injuries?
Yes, my opinions are based on medical records because those are the objective evidence, forensic evidence in this case. So in the majority of my cases, I start with medical records as objective records and formulate opinion.
Your Honor, at this time I'd move for the admission of defendant's exhibit V. Victor.
Is it just the slide?
Just the slide.
Just the slide. I have no objection to just the slide.
Thank you.
What'd you say? V?
Victor.
Victor? V.
I'll show what we marked. Is that the slide you were talking about?
Yes.
Okay. Shows Todd Stermer, who at the time was age 42, 5'7", 180.
That's correct.
And blow this up a little bit and see if we can describe some of the injuries, and you can explain what these injuries mean to us.
Well, and maybe I can give you numbers because really that's so small that I know what is on it. I have a hard time to read
All
it,
right,
you know?
let's just tell us what the injuries are.
If you go to those are the injuries, and the first three injuries relate to
No, I
burn.
just said.
I really don't deal with that, but I include it in the analysis. If you go to number 4,
I
go
just
to
said she didn't
item
kill
number
him
4.
with the car. I said the fire killed him. I was saying that
Very good.
before, but
We have 4.
I was saying that before. But yesterday I looked up cause of death in my notes, and he died from the fire. So I just said the fire killed him, not that she ran him over. So this is a waste of time because that's not what killed him. The fire killed him. I do have doubts that she set the fire. So she's being charged with arson, first-degree murder. She's not being charged with anything to do with the van. That wasn't the cause of death. I don't know who set the fire. I love you too. So I don't know. I don't see a direct, for sure and certain, that I have reasonable doubt that she set the fire. And I don't know why the defense is not pointing out that he has set fires in the past. Or someone did, because they lived in another house that caught on fire. I'm sure the jury, I'm sure that will be talked about. But the ME agreed with the ER doctor. They both said that it was thermal. The cause of death was thermal. So I don't know why this expert was called, because that's not what killed him.
Lacerations on a skull. So we have evidence of 4 separate contacts to the head.
But you're right. I did say that before, but I changed my mind.
And the next one, if I can lead that, go to number 5.
Okay.
I guess. I don't know.
Okay. Minimally depressed marks defects of the outer table of the skull, underlying two of the lacerations.
Let's break that down. What is a depressed mark or defect? And then I'll ask you, what is the outer table of the skull? What are we talking about?
Skull is like a sandwich. We have a dense layer at the top and dense layer at the bottom, and we have this porous layer in the middle. This description indicates that only top portion of the dense layer of the skull was, as was described, depressed. Normally, you have a linear fracture all the way through the skull. It didn't happen. It just simply top portion was compressed. Now, it is important that that type of description relates to two lacerations. So already we are connecting the two lacerations to one event that is quite similar in nature. I mean, the chances are that you might have a very similar outcome from completely two independent blows. It can happen, but clearly this will be more consistent with head contacting something that is on one side and another side. There's a rigid object in one motion, head motion with respect to the rigid structure created those laceration and depressed,
I think this
minimally
backfired.
depressed skull.
In two spots.
Two spots.
Okay. What else?
And now what I would like you to maybe skip to go to number 7.
All right.
Okay, so now we have a depression of outer area of the left parietal bone of the skull.
What's the parietal bone?
Side bone. If you look at the midline to the temporal area, this is parietal bone. So we have depressed area in that location. It's on the left. Now, if you go to number 10, now you have a depressed mark on an outer table of right parietal bone underlying laceration. So what is important that we have in both areas, left and right, we have an outer area of the bone. So now we know that the two areas that the records refer to are on the side of the head. The size is somewhat different. The one on the right is about 1/2 inch, the one on the left, 1/4. That's not that critically important. Important thing is that the nature of the damage is the same left and right. So both of those happen from one particular event.
Okay. What else do we have?
Now I would like you to go to item number 8. Okay, V-shaped laceration in a midline, posterior, frontal/anterior parietal skull over the vortex of the skull. A lot of words, but midline is midline of the head. Posterior is the back. Well, the word frontal tells you is front. / anterior, because anterior really means front, paradial skull over the vortex of skull. So there's some laceration close to the vortex area. Remember, we have 4 lacerations. We explained 2. Now we are dealing with the 3rd one on the vortex.
Where are these words coming from?
Directly from, by the way, notice that after each sentence, I have a parenthesis, document 1:17. That's document 1 in my list of material studies. That's the autopsy record. And :17, that's page 17. In addition to it, I attach the date for this diagnosis, 187.
Date of the autopsy.
That's correct.
Okay. Where are we going next?
And the last one really would be number 11. And again, talks about this 2.5-inch gaping linear laceration on posterior back midline region of paradial occipital skull. Now, occipital skull is the backbone of the head. So now we have evidence of contact that extends from the vortex to the back. And those are 2 separate lacerations as identified, and we have 2 on the side, we have 4 lacerations.
Okay. Anything else we need to see there?
No, those are the most important aspect to us, because lacerations are AIS level 1. AIS stands for Abbreviated Injury Scale. It's a trauma scale that we use in civilian and military organization to link the diagnoses to engineering parameters. Now we want to medical field and engineering field to communicate. And AIS scale allows us to do that. Based on AIS scale, we can use the evidence.
What did I do? Darn it. Sorry. Sorry. I don't know what I did. StreamYard.
See the likelihood of fatality from it is 0. The next level, AIS level 1, is fracture. We're going to have linear depressed fracture.
I give up. What is happening?
Called comminuted or complex fracture of the skull. Here we don't even have linear fracture because it doesn't go all the way through the skull. But still, AIS level 2 score because there is portion of the skull that is fractured. And probability of fatality is very low. The survival rate is 99.2%. So 99.2% likelihood of survival from this kind of injury.
And tell us that Were there any brain injuries involved here?
There's no indication of the brain injury. In other words, the bone heals, and they very often, there's no residual effects. The problem is that we have a soft tissue that might not heal. So in terms of the brain head injury, we are very much interested what happened to the brain. There's no bleeding in the brain. There's no contusions or bruising. Contusions is bruising that happens if you get hit in the head and brain strikes the internal surface of the skull, it might bruise. Bleeding can occur. No laceration. So there's nothing in the brain tissue that was identified as evidence of trauma.
And the AIS-2 level would be considered what? How would you describe that level?
It's called moderate. You don't have evidence of internal brain trauma, and level of survival is 99.2%.
And in this particular case, you had picture positive for Todd Stermer's blood. Do you have an opinion, doctor, whether all the injuries that he suffered, all these traumatic injuries, other than the rib fractures, dealt with contact from the van?
Yes, everything is consistent.
I don't think you can opine on that. I think you can say those injuries are consistent in that, but we're outside of the scope here, what he could testify to.
Well, I'd ask if it's consistent with. I
Thank
think
you.
that's appropriate.
Are they consistent with a single event?
They're consistent with single event, the interaction between his head and the pickup going in opposite direction.
Okay. Do you have a slide or a photograph that depicts the injuries to the skull and then also the components of the undercarriage?
Yes, I do.
Okay. Your Honor, just to advise, there's just me one picture of the skull from the autopsy showing some lacerations. And counsel has that.
Yeah, as long as it's just the one slide in the report, yeah. That was right
Okay.
above the one we've already admitted.
I believe that's exhibit
Year one.
Q. Okay. Move for the admission of exhibit Q.
And you. Yep, we have a
Go.
queue. That was this morning.
Figure 1. Oh, you, I'm sorry, you. Sorry.
Okay.
Thank you, Ms. Heidi.
And jury, it sounds like there might be a little graphic here, but bear with us. We'll get it on and off the screen.
Thank you.
Mr. Mueller?
Doctor, can you show us,
Yes, I'm admitting you.
good. Can you show us what you're talking about in terms of injuries and tying it into the injuries of the skull?
Can we focus on the top left corner of this composite and then prepare this composite? Right. So we are looking at the top of the head, the nose is up to the ceiling. And at first, let's look at the two lacerations from the side. Those are the two lacerations that we discussed initially.
This
Then
one
we
here?
have the big laceration, and there are some small fractures, outer layer of the skull. And then we have a laceration on the midline in the vortex. That's the laceration. And if you look at the laceration to the vortex, the force applied was obviously into the head and backwards. So the vehicle was going backwards, so his head was moving forward to end up with this kind of
Relatively.
injury. Relatively.
You understood that all the blood was on the front surface of the undercarriage components.
That's what I understand.
So what does that tell us in terms of any of these other pictures that you're talking about on this
Well, what is really is telling us that from biomechanical perspective, I see one event, this individual with the head orientation into the front bumper of the pickup, and the pickup going over his head, and those injury took place.
Okay. Getting back to that first opinion about a single event, is your opinion, having read Dr. Markey's testimony and his autopsy, is your opinion consistent with his that none of these injuries were fatal?
That's correct. I am.
Then let's talk about what type of impact. When we talk about forces, we're talking about loads, right?
Yes.
Loads in your business.
Yes.
All right. Tell us, do you have an opinion, given all the material you reviewed, whether or not these injuries are consistent with the low speed impact of the vehicle?
It is. Actually, cadaver studies show that head striking a rigid surface at 5 miles an hour, it's like 7 feet per second. It's like slow jogging speed, is sufficient to cause linear fracture. And the forces that were measured was 1,500 pounds, 5 miles an hour impact against a rigid surface.
So what does that mean in terms of, are we talking about low speed, high load?
Yes, I mean, low speed, 5 miles an hour is not the high speed. And if the impact happened, I guess not the right way, the wrong way, skull fracture can occur at that velocity.
But here it didn't.
It did happen. We have some minor fractures, which I would not, again, classify as linear fracture, somewhat less than linear fracture. So less than 5 miles an hour.
Do you have an opinion based on your review of the photographs, the medical records, the injuries, in terms of the relative height of Todd Stermer's body as to the vehicle on impact?
Well, the only thing I can talk to you about is where the head was. So the head to be somewhere at the height of the bumper or somewhere below, because they had to go under the carriage.
Finally, there's been some talk about the possibility of a frying pan being involved in this impact, in an impact. First of all, as a medical expert, do you deal in possibilities?
No, I don't. That's speculation.
In terms of your review of this case, do you have an opinion as to whether there is any evidence that suggests that a frying pan could have been involved in this trauma?
I don't see any evidence, because all the evidence that we have aligns very nicely in the sequence that I described to you. So more likely than not basis, there was only one event, the interaction of his head with the undercarriage of the vehicle.
And can you describe any significance to, I think you said, some symmetry between the lacerations?
It is. From very beginning, I mentioned to you the side fracture, position very symmetrical, pretty much the same extent of the fracture, meaning the same load. So something there under the pickup, how it's designed, that there were two edges of sort that came in contact with his head in those two locations. And then there was less severe, there was the contact with the midline from the vertex to the back of the head.
Okay. Your Honor, just give me 1 second. Doctor, thank you for coming here from Fargo. No more questions at this time, Your Honor.
Ms. Siderbean, any cross?
Yes, thank you, Your Honor. Good afternoon, Doctor.
Good afternoon.
So I just want to be clear, you study the force that an injury, what force it takes to cause an injury on a skull.
That's correct.
In lay people's terms.
That's very well described.
Okay. You're not a doctor of medicine.
Right, I'm a doctor of medicine.
You're not a forensic pathologist.
That's correct.
And you're not here to opine about injury patterns or that sort of thing on a body at autopsy.
No, actually, injury pattern is part of biomechanical evaluation because we are talking about the forces. And we are very much interested in the pattern because lack of pattern creates additional body kinematics, additional body motion. We are interested in that. So symmetrical pattern obviously tells us not much rotation either way, just uniform body position. So pattern is actually part of the geometry, part of physics, not the physicians do not understand what pattern is. We all understand.
So I'm going to
But-
stop you there. You're talking about patterns of maybe where lacerations are.
Correct.
So you're not looking at like a pattern, like if somebody were to be hit with something with dots on it, that it would cause a pattern on their skin.
No,
We're not talking about that, right?
No, I do, or we do, because the type of imprint, you have a silly party, you put the finger, and somebody will ask us what caused this imprint. It's important that we will be able to figure out it was a human finger that left the imprint. So no, we are very much interested in the geometry of trauma.
Okay.
We are.
But looking at this, we're just looking at lacerations and
Lacera-
where they're located on the skull.
Lacerations, nature of lacerations, location of lacerations. More than that, the type of evidence of the skull fracture. Both sides, we have just the top layer of the skull. What the chances are that random two forces come striking the head and only top layer of the skull is fractured, not all the way through or not at all. Well, the situation is very simple. It's some kind of symmetrical orientation and it will give you the same amount of force and approximately the same amount of depressed fracture. There are some small differences. One is a quarter inch, in other words, is half an inch, minor difference.
So when you're talking about the depression, you're talking about depressions into the bone.
Yes.
Be possible for there to be depressions in the skull created by different impacts.
Theoretically, yes, anything can cause, if it's,
Caused by a blow or a different trauma.
I don't deal with the possibility, on more likely than not basis, no. Everything is so symmetrical. I cannot envision two separate blows and give you pretty much the same type of laceration and top of the skull fracture. That's so unusual. Typically, you have no skull fracture or fracture all the way through. So somewhere in the process, the force ended.
So doctor, I just want to stop you there. You have the two that you're saying are symmetrical, but you have one top and one in the back, correct?
There's no fracture, there are less lacerations.
And indentations?
Indentation, yes.
Okay. Okay. And so all of those are then what we would classify as blunt force trauma.
Yes.
Okay. And I was taking a look at your report, and I think you testified as to what you reviewed. And And it included the autopsy report, the car specifications, the trial testimony of Dr. Markey, and the photographs. Are those the photographs of the autopsy?
Yes, and you saw also some photographs of the undercarriage of the vehicle.
Okay. So you didn't review any of the testimony that any of the witnesses have provided?
No,
Okay. And a blunt force trauma to the head, if somebody were to hit a skull, a human skull, with an object, would you expect to see the same sort of indentation or laceration?
sure, you can hit the skull any place, an indentation, a skull fracture.
And so basically, what you're looking at is the amount of force that it would take to cause these lacerations, and you're concluding that they're not fatal.
Correct. No, just based on a skull and lack of brain injury. If there will be any bleeding, contusions, laceration, you will hear me talking about that. And that injury will have a higher AIS score than skull.
So you are aware, after reviewing the photos, or are you aware that there were actually several different spots where there was blood underneath the van?
Yes,
More than 4.
yes,
And are you aware there were multiple injuries that were seen, not just on the head, but also on the body?
yes. If you look at the medical records, I list at least some of them: arms, thoracic, rib fractures, and so on. Extremities, yes, but those are of minor significance in terms of the fatality.
In terms of the fatality, but we can agree that there's definitely more injury than just on the skull.
Yes,
And we can agree that there are multiple points underneath the van.
yes.
And you can't say what part of Todd's body touched what part of the van.
No,
Because that would be speculation, right?
no, I would probably, if I will have exemplar van and three-dimensional model of the skull, I bet we could go there and match what portion of the undercarriage create those two imprints. Lacerations, they'll be more difficult, but if you already have a one point identifying the indentation to the side, you're in a good shape to identify where the head was and probably find the location for lacerations. But no, I didn't do that.
Well, and there, we can agree there's more than one laceration. So you'd have to match where the laceration on the back came from, the laceration on the side, the laceration on the arms. You can't do that. That's not what you're here to do today.
It didn't do any other lacerations except the head, but the fracture on the side and laceration goes together. And then you have a impact to the top and then flexion of the neck, and you have a continuation to the back, although there was no injury to the neck.
So I'm going to ask you that question again because I don't think you answered it.
Okay.
You're not here to match.
Shut up.
Yes, that's fine.
You're not here to match the injuries that he sustained on his back, his side, his arms, to any particular portion. You've only analyzed the head.
That's correct.
And you can't say, sitting here today, if it would have come from a blow prior to being hit with the van, right?
That's correct.
And you can't say what particular blows on his head came from the van.
No, as far as the blows to the head,
Your Honor, it's not unresponsive. I just needed an answer. Thank you.
Are you moving on or?
Yeah, I'd
Okay.
like to move on.
Okay.
Thank you. And I just want to be clear, you've reviewed no testimony from any other witnesses, and you've seen no testimony that was provided that somebody claimed that Todd Stermer was hit prior to being hit by the van with a blunt object.
Correct. Then have not seen this testimony.
So are they implying he was hit by the van to cover up a previous hit?
I have no further questions for this witness, Your Honor.
Just a few more before I wrap up, Your Honor.
You did account for in your findings other lacerations on his body, right?
Oh, I knew what they were. That's why it's in the medical records, and some of them I listed in my summary.
Okay, go to
That's not the same thing.
number 14.
Yeah, I think this made things worse, not better.
You noted the laceration on the right rear shoulder and upper back,
Correct?
and the upper left arm,
Correct.
and the lateral back and chest. So you noted all those.
Yes, I did.
But they didn't have to do with anything having to do with your analysis of whether or not these injuries were serious enough to have any type of chance of being fatal.
Correct. It's AS, any lacerations, abrasions, AS level 1, 0, likelihood of fatality.
Your ultimate opinion, or one of the opinions you have, though, is given the nature of these lacerations, the symmetry, it's more likely than not that everything happened from a single event, all those head lacerations
Yes, the
And
head
fractures.
lacerations, yes.
and fractures.
And what?
And fractures.
Yes,
And they would have been from the van impact.
definitely.
Thank you. Anything else?
I just want to be clear. You said that the two on the side of the head were symmetrical. Those would have maybe come from one incident. But then I believe your testimony was that the other ones were not then associated to the two on the side.
It might be. I'm just saying very much symmetrical, and then you have a top and extending to the back. I did not match with the exemplar vehicle, so I don't know if the structure, undercarriage structure, they will leave the side depression, also have close a surface consistent with the contact with the top. If it does, everything happened right there. If not, it happens somewhat later.
And that would address 3 out of the 4 lacerations.
No, because this laceration on the top, there's an extension. Everything is the midline of the head, so it's extension to the back. Now we have 4.
I just wanted, the slide that was shown showed a laceration, and I'm just gonna show you your slide, showed a laceration on the top of the head. That's the laceration we're talking about here, right? Right? The one on
Yes.
the top.
Yes.
And so this photo doesn't show the laceration in the back.
This photo doesn't, because the head is laying on something, so it doesn't show the acceptable laceration.
So the laceration on the head goes, for lack of better description, from ear to ear side.
No, go from it's extend, have certain width, and goes from the top to the back.
So what we're looking at in this photo that you put up on the screen, is this the face?
That's the face.
And this shows the injury going across the top of the head this way.
No, there's an impact and tissue burst that way.
Okay.
So if you have a sphere and you hit material, you get a laceration perpendicular to the direction of the force. And some of the tissue will be pushed in the direction of the force. That's exactly what happened.
Okay. And then this does not show the laceration in the back of the head
No,
because the body is laying on its back.
yes, but it's in medical
Okay.
records.
And you can't say where the blood came from on the van, like in the different areas in the photos you looked at?
No, I mean, other areas, the bleeding, it could come from different areas. And remember, blood is splatter. It just goes in different directions. So sometimes it's difficult to pinpoint where exactly, what's the original source of the blood.
Especially if you have lacerations on your head, your arm, your back, and your side. Would you agree?
That's correct.
I have no further questions, Your Honor. Thank you.
To make sure we're clear, in your expert professional opinion, you saw no evidence that's consistent with impact from something like a frying pan, right?
That's correct.
Thank you.
No.
Your Honor, I just want to clarify, you testified that you can't say that a blunt force object could not have caused one of the lacerations.
No, I said, in general sense, laceration can be caused by blunt object, period. Now, totality of the evidence, or more likely than not basis, how everything is lining up. That two contacts on the side, and one extended contact from the top back.
But the totality of the circumstances would also take into account testimony that the defendant said she hit him with an object. Would you agree with that?
And it goes way past the.
One minute. I'm going to sustain the objection as to foundation.
Did you take into account any of the testimony from the trial?
I was aware of this fact from reading trial testimony of physician, and
When did she
more
say?
likely than not basis, I don't see any evidence of that. I just see the evidence on the head from contact from undercarriage of the forehead.
But you can't say, from what your prior statement was, you can't say that another blunt force object did not cause one of those lacerations.
More likely than not basis, everything fits the contact with the undercarriage. That's
Unresponsive,
all.
Your Honor. It's unresponsive.
Absolutely responsive. He's answering the question.
Sir, if you could try to just, I
Yeah.
think if you can answer it with the yes or no, if you could do that.
Is it possible
Oh.
that one of the lacerations was caused by a different source of a blunt object?
Possibility is speculation. Is it possible? Yes, you might have an impact and no trauma. Then we won't know that really happened. So
Your Honor, it's unresponsive.
it's possible.
Thank you. I have no further questions.
Your Honor, you also said possibilities are speculation, right?
Yes, it is.
And do professional experts engage in speculation?
No.
Why not?
Well, because there's infinite number of possibility pretty much for everything that happens. So we are evaluating things from more likely than not basis. That's why we are evaluating the pattern. Everything fits in one particular motion. More likely than not, this is how it happened.
And one single event being the van impact?
Yes.
Thank you.
You can't line up those injuries to the parts of the van.
Objection, asked and answered.
I'll allow it. She's asking the exact parts of the van.
No, not specific parts. As I said, I did not match the specific geometry of the.
All around in circles.
Therefore, you're speculating about how these injuries occurred.
Absolutely not, because I know the outcome. I see the blood and undercarriage, so I know the body was there, and I see the type of trauma, laceration, and under laceration, I have some evidence on fracture. I can guarantee you that's a rigid object in some kind of rounded edge that came in contact. And we have a symmetry to it, consistent with similar structure of the undercarriage.
The ones on the side,
I have no further questions.
not the other one.
Thank you, Your Honor.
You good?
I'm all set. Well
Okay.
done.
Thank you, sir. Oh, I'm sorry, jury. They often have questions. How could I forget?
I have a feeling that they weren't allowed to talk about the other house that burnt down, because to me, that would be the defense's best avenue to say they lived in a house that burnt down before. Unless that one was ruled an accident or like an electrical issue or something like that. Which maybe that was the case. Maybe that's why they're not bringing that up. But only one person has mentioned it. I think that was Todd's brother. And I think the frying pan that they found, and it looked, well, I mean, it was burnt because it's in the fire, but it looked like an iron skillet. But it could just have been a burnt frying pan. But it was in the basement. And I remember she specifically asked if the room above the basement where they found the frying pan was the kitchen. And it wasn't. The kitchen was in a completely different part of the house, implying that she hit him with a frying pan and then took it with her to the basement. But I still, some suspicious stuff went on. Her story changed, but I still don't see a direct, yes, she set the fire. Everything she said about getting the boys out of the house because she knew they were going to fight, that all could be totally true. The way she filled up the gas can, that might be
I have some questions from the jury.
The gas can. Who
In
knows?
your biomechanical analysis of the injuries, are you assuming that the object being struck, namely the skull, was in a stationary state at the time of
I don't know.
impact?
No, it doesn't have to be. The relative velocity has to be about 5 miles an hour. So it could be 2 miles an hour and 3 miles an hour. 2 miles an hour of the skull and 3 miles an hour of the pickup.
If so, could the severity and analysis of the injuries be altered if the object, the skull, was in motion either toward or away from the vehicle?
No, the severity is what it is. So the 5 miles an hour is sufficient to do that. And it could be skull going 3 miles an hour away, and then the pickup will have to be going 8 miles an hour into it. So the differential 5 miles an hour.
Would you clarify the direction of travel of the van during the impact event?
That's true.
The only thing I can tell you is the direction of the van with respect to the head. The head is pretty much directly into the bumper, a little bit under the bumper, and the van is coming over.
Did you computer model the impact event?
No, there's no reason to do a computer model because the evidence are so straightforward and based on the questions that I was asked, there was no need for that.
Based on your examination of the data, do you think Todd was laying face up or face down when hit by the van?
It was face down. We know that at the very end, there's some medical observation about
That's hilarious.
dirt in the nose and dirt and grass in the mouth. So definitely it was face down, but somewhat off the ground initially when the impact occurred, but facing down.
Okay, thank you, sir. Council, any questions in light of those questions and answers?
Thank you. That face down is based on your review of the medical records, the autopsy records, and the photographs of his face.
Yes.
Why was the gas can in the front yard? This whole thing's a mess. I have no idea. I'm just glad I'm not on the jury.
Would you agree, based on your biomechanical engineering background, that if all the blood spots are on the front side of the undercarriage components, it would mean that the van was going forward?
Yes.
And simply, when you're asked about the skull being stationary, absolutely still versus there could be a relative movement of the skull with respect to the bumper.
Oh, the relative motion of the skull before the impact, I don't know. There's no evidence. So from physics perspective, I cannot tell you. I know that what was the orientation at time of impact, quite symmetrical. It could be some waving of the head before, but at the impact was quite symmetrical and vertical because of both lateral laceration and skull fractures are so symmetrical. So could not be tilted to an extent left or right.
But it was face down.
It was facing down because we have the side impact and then we have a top and the continuation to the back.
Thank you, doctor. Appreciate it.
So I'm sorry, I just want to make sure I clarify. So you're saying if somebody were moving away from the vehicle and the vehicle then was coming from behind, then it would be higher than 5 miles per hour?
The actual velocity of the vehicle would be higher if the body would be moving, let's say 2 miles an hour back, then it would be 7 miles an hour.
And if the body were moving 5 miles an hour forward, then the vehicle would have then traveled faster.
If the body is moving 5 miles an hour forward, the vehicle could be stationary. And you have 5 mile an hour impact.
Well, the vehicle would not be stationary when they make impact,
I know, but
unless the body ran into the vehicle, correct?
Right. That's the test, the 5 miles an hour test and skull fracture down that way. The surface is stationary and the head hits the stationary rigid surface. So the relative velocity between the head and the impact surface has to be 5 miles an hour. It doesn't matter.
So if the object is going faster, then the vehicle would have to go faster in order to then create that 5 mile an hour.
You have to give me the direction because it depends what direction. But yes, the difference in the velocity, the vehicle has to be going 5 miles an hour faster in the same direction, right? In the direction of the skull to get the fracture.
I have no further questions.
I
Your
fail
Honor.
physics.
If the body was going 5 miles an hour, that you said is jogging speed, correct? You understand the fact of this incident is that Todd Stermer was likely on fire.
Correct.
And you would also expect lower body injury, right, wouldn't you? House based on questions I received.
I will overrule that objection.
Thank you. Did you see any lower body injuries?
But the abrasions that we talked about, back and shoulders.
No
arms,
fractures, no nothing.
No.
You would expect if a body was running and got impacted with a van, you'd have to be, and let's do the quick math. For a change in velocity of 5 miles an hour, if the person's running away at 5 miles an hour, the vehicle would have to be at 10, wouldn't it?
Yes.
Right. You didn't see any evidence of that, did you?
No, there will be fractures in this now.
Thank you. Have a safe trip back to Fargo.
Thank you.
Jury, any other questions? May he be excused from his subpoena, counsel?
No subpoena, but he may
Okay.
be excused.
Okay, thank you, sir. Thank you. Counsel, can you approach, please?
Second.
I never did a seance as a kid. We did light as a feather, stiff as a board. And it never worked. I don't even remember how we did it. I remember we had one person lay down and we put 2 fingers underneath them and we lit candles and there was some kind of incantation we were supposed to say. And then we were supposed to be able to lift them and it never worked. I don't even remember what we said though. We always did that at summer parties and it never worked. That's the only thing that we ever did. We never did Ouija board. We never did seances. Never did anything like that. Just light as a feather, stiff as a board. It's the only one we ever did. I don't know why we never did any of the other ones.
A short break, hopefully, maybe we'll make it your usual 15 minutes. And we'll go as late as close to 5 today.
If you're on a jury, can you say, I don't know? I guess you can't, can you? You got to sit and listen to what everybody else thinks. And yeah, I know. And, like when I watch like ghost hunting shows and stuff, they're ready. And they're like going to Ouija boards, but then they like
Mr. Mueller, you may
do
call your next
homemade ones like
witness.
on the floor and stuff. I'm like, it's the same thing. Just because you don't get a home like a store-bought one, you make your own on the floor. It's the same thing as a Ouija board.
You solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And once you're settled in, we'll have you give us your full name and spell the last, please.
Gregory James Stormzand, Stormzand.
Sir, I'll have you move that microphone closer to your mouth so the jury can hear you. Thank you. Mr. Mueller?
Thank you, Your Honor. Good afternoon, Mr. Stormzand.
Afternoon.
Sir, can you tell us, what is it you do now for a living?
Retired.
Back in 2007 in January, what did you do for a living?
Back then, I was the Assistant District Fire Investigator, which is out of Grand Rapids, Michigan.
Do
For
you
the
folks at the
Michigan
Michigan
State
State Police have different areas and districts that you cover?
Yes, sir.
You are actually a certified fire origin and cause expert?
Yes.
How long have you been doing that at that time, 07?
At that time, I got in the State Police Fire Investigation in 1999.
Really?
I completed their training in 2000, so it's from 2000.
Okay. Back in January 7, 2007, there was a fire at the Stermer residence in Lawrence, Michigan. Your name came up as being part of an investigation on January 8th, 2007, the next day, with a man named Scott Leroy. Do you remember at all going to the Stermer house in Lawrence?
Just vaguely since then, yes.
At that time, if you were 2000 and Mr. Leroy was certified or became a fire inspector in 2001, wouldn't you have had seniority over him?
It's not much as seniority. I've been in the unit a little longer than he had. I was
Okay.
in, 99, his is 2001.
Would he have had jurisdiction over this fire? It's folks were interesting.
Correct, yeah, it'd be his area of responsibility.
You were there then to assist Mr. Leroy?
That's correct.
Okay. Do you recall participating in any type of investigation at the scene?
Not specific investigation. He asked me to do a scene sketch of the residence, basically do the footprint, basically the outline of the house.
Okay, let me, if I can. May I approach, Your Honor? Thank you. Just going to show you something. Does that, in the upper right corner, can you just tell us what you're looking at, just to kind of jog your memory?
The upper right-hand corner would be the case number 04-18-07. The date is sketch not to scale.
But it just GJS are your initials?
Yes.
All right, that's what you're talking about.
Okay, yeah, that would be my initials. That's how I know I did this one.
Do you recall the damage to the level of the house?
It was recalling from the, thinking back, it was pretty severe, basically over the living room area of the house, which is on the main floor.
Okay, let me show you a photograph, and we can either look at it on the overhead. Or if it's easier for you, just on this blow up. But does that bring back? Yeah, that looks like the house we did.
I'm going to object, I guess it's the lack of foundation, Your Honor. I don't know if he's ever had this view of the house before.
He was there on January
Has
8th
this
with
been
Mr.
admitted?
Leroy.
This has been admitted, yes, but my concern is a foundational issue with him testifying for this. I don't know that he was ever up in the air in this case.
Why don't you lay a foundation?
Sure, you were at the scene, correct?
Yes, did a walk around, and to the best of my knowledge, I thought that to the best of my recollection that Scott led me through the house and a quick, walk around and say what happened and all the general description of what he
Does
saw.
that jog your memory as to that's the house we're talking about or no?
That appears to what the house that I remember looked like.
Okay. Did you take any photographs that day?
I don't photographs.
Did you make any, other than these
Other
two
than that, I
sketches?
was asked to do the scene sketch, yes.
When you're doing a scene inspection, obviously this is considered a big loss, a total, lot of damage.
Mhm.
Yes?
Yes, sorry.
Not every fire is the same. Some are kitchen fires, right?
Some are very small, yes.
Right. When you have, and especially, not that you'd treat anything else differently, but when you have a death case, it's a serious case.
I'm going to object, Your Honor. I think the issue is we're not qualifying him as an expert in cause and origin. He sounds like he's testifying as a lay witness. Now we're asking him about how an investigation is conducted. I don't think that
There are, again, I know there's a legal objection.
Are you objecting as to,
relevance and he's not an expert.
okay,
He's not named as an expert. He's talking about his experience. He's even more experienced than Mr. Leroy, so he's talking about excavation, which is the heart of this case.
well, I think it sounds like it's an expert question, so I'll sustain the objection.
In this case, do you recall participating in any type of excavation of this damage to this house?
No, I do not recall doing an excavation.
If you had been part of an excavation, of the house, would you typically do a report given your experience and training?
I would, depending on if there's anything significant that we found in the incident, I would maybe do a supplemental report if requested by the senior,
it certainly
by the officer.
Certainly would be important to do an excavation in order to find something significant, right?
It can be, yes.
Okay. And despite you were in an assistant position back then, correct?
Yes, yes, sir.
You don't recall doing anything of the sort, reports, photographs, anything?
No, sir.
Thank you. I don't have anything else.
Mr. Blair?
What was the point?
Good afternoon, Mr. Stormson.
Afternoon, sir.
What was your rank with Michigan State Police at the time?
Specialist sergeant,
Specialist sergeant?
same as, yeah, Mr. Leroy at the time.
Okay.
Mr. Mueller, do you want your iPad? Cool. You want your, oh, sorry. Hand it to you. I just don't know if you want to touch it or not.
Break it, boy.
I make that kind of money late.
And so you were both specialist sergeants, correct?
Yes.
Sometimes referred to as detective sergeants?
Well, detective specialist sergeant, call us, technically my badge said specialist sergeant. So, yeah.
So you were both of equal rank.
Yes, sir.
And in the hierarchy of the Michigan State Police, there are sergeants, and then there's actually like a lieutenant above you guys that's the manager of everybody, correct?
Correct.
And so on the 8th of January, you were actually just called down as an assist to Mr. Leroy, correct?
That is correct.
And you were there to just kind of help him with whatever he might have needed help with, correct?
That is correct.
And would it be fair to say your memory of what you did that day is fuzzy?
Yes, sir.
Don't necessarily remember everything?
Correct.
And so when you say, when you're asked questions about an excavation, you don't specifically remember doing an excavation?
I don't specifically remember it. I thought we might have, but I don't specifically remember.
Okay, you thought you might.
Yeah, but like, how could I answer that? Through the years, had so many fire investigations. We've worked with each other that they all get pretty foggy after the years.
And would you agree with me that it's pretty much state police protocol that whoever's like the lead on a case writes the report?
That is correct.
And that sometimes people that assist don't necessarily write supplemental reports?
Correct.
And would you agree with me that what you had on January 8th, 2007 was basically a fairly limited role at that scene?
Yes,
You
I would
recall?
say that.
Okay, all right, thank you. I have no further questions.
Yeah, so you're telling us that if you had done something significant as an excavation of a total loss, that you wouldn't have written any report?
If I would have done an
If you
excavation,
would have even assisted and helped in doing a major excavation, you wouldn't have written a report? account for your
I might
day?
have, depending on what we found, or if nothing. Normally, lots of times, the senior investigator, the person writing the report, would put in, was assisted by so-and-so doing this, taking photographs, or whatever the specific request was done.
You would certainly expect a thorough report to be done though, right?
Or,
Yeah, I didn't ask you that.
What's the objection?
Ask and answer.
I'll overrule that.
Go ahead. You would certainly expect a thorough report to be done.
or in the report, a section would be during the excavation, so-and-so, you found this or that.
Right.
Yes.
Not simply omitted.
Yeah.
Okay. Thank you, sir. Thank you for your time.
No further.
Jerry, do you have any questions of this witness? No questions, excused from subpoena if he's under one? Yeah.
I don't
Sir.
have, I do have one subpoena.
Okay, sir, you're excused from subpoena, thank you.
Thank you, sir. I don't know if we approach.
You may.
think the dude needs to vet his witnesses a little better. Make sure they've got some valuable information. He strikes me as a really impulsive person. I don't know, maybe impulsive is the wrong word. Entitled is much better. He's it strikes me. I'm surprised he's married. He's got a wedding ring on.
Jury, after I said we'd run till close to 5, I'm gonna let you go early today, so, and come back again tomorrow at 9 o'clock. Remember your instructions, no discussion of the case with anyone else, no media, no social media, investigations, research, anything of the sort, okay? You can leave your notebooks in your chairs and report directly to the jury room, and have a nice evening.
So what do you guys think? Guilty or not? I don't know. I mean, the circumstantial evidence is weird. But I don't know that I can say it proves anything. It just proves that she's weird.
Counsel, the jury's left. Any matters to address?
No, Your Honor, I think we'll be here early to talk about
Your
jury
instructions, 8:15.
8:15 sounds great, Your Honor. Thank you.
Thank you, Ron.
Are we doing that in here or in chambers?
We can do it in chambers, so I'm just going to limit it to just lawyers, so it's not too crowded in there.
What are we doing? I'm
Just
sorry.
limiting we can meet in my office for finals.
What I'm confused about, and I don't know if any of you guys can explain it to me. She was found guilty, and then the conviction was overturned, and then they decided to try her again. I think that most juries would lean guilty, but I don't see anything that directly says that she started the fire. But I'm confused about double jeopardy. Doesn't double jeopardy apply? How is she being tried again? If her conviction was overturned, doesn't that mean she should be free as a bird now? I don't understand how they're allowed to try her again. That's what I don't get. Yeah, I don't know. If I was on the jury, I would probably hang it because I don't know. And the part of her hitting with the van, it didn't kill him. But see, that's another thing. It could have been an accident. But like, I totally get your house is on fire. I lose my cell phone all the time. I'm not gonna, in a house that's on fire, I'm not gonna be searching my house trying to find my cell phone. I'm gonna run out and get in my car. But also, my keys are hanging on a hook by my side door. If the fire's over there, I'm not gonna have access to my car either. What am I gonna do? Oh, okay. All right. That makes sense. I knew it was ineffective assistance of counsel, but it didn't click that that meant she could be tried again. I don't know why it didn't click. So it wasn't on new evidence or judicial error, so then it's overturned without prejudice or what. See, that's another thing that, and I asked Alita this one time and I still can't keep it straight. Which is without prejudice and which is with? Without prejudice means they can be tried again, right? Without prejudice is you can do it again, but with prejudice means you can't. Is that right? I don't know why I can't get those two straight. Yeah, there's just too much reasonable doubt. Because either one of them could have set the fire. Or it could have been accidental. Like the one, he was a weird expert, but he could be right. It could have been a chimney, what do you call it? Chimney chase or whatever. Oh, okay. Conviction was overturned, not the charge itself. Okay. Okay, without prejudice. Okay. Thank you guys. I don't know why I can't keep that straight in my head. I don't know what it is. It just doesn't stick. Yeah, I just keep thinking about, I heard, or I don't know, maybe I'm remembering it wrong. I've got it in my head that he set 2 other fires. And maybe they didn't say he set that other house on fire whenever his brother was up there talking about it. He just said it caught on fire, and they've never said how it caught on fire. I'm thinking that might have been a motion in limine, so the jury doesn't know how the other house caught on fire. That's just my assumption. I don't know if I'm right or not. But they didn't say how that other house caught on fire. Just that it burned down. So that right there makes me think that it could have been Todd. But they didn't have insurance. So why burn your house down if there's no insurance? Unless you're doing it to try to kill a person that's in the house. Or usually if you're building your own home, it's because it's your dream house. So either maybe it was her dream house. They had all that land for the horses and everything. So maybe Todd was like, I'm going to show her. I'm going to burn the house down. I don't know. But there's too many. That's reasonable doubt. That's what reasonable doubt is. When well, maybe it was this or maybe it was that. There's not. When you see too many other scenarios, that's a definition of reasonable doubt. So, and maybe she did accidentally hit him in the car. And maybe she didn't send the boys to the mall because she thought I still think it's weird that you are gonna have a fight about getting divorced, but then you go in your bedroom and lay down and take a nap. But they seem like kind of a strange bunch of people, if you ask me. So I don't know. Speaking of that, I am hoping because I watched Lawyer, when he was talking about how widespread the Karen Reed trial was now, how everybody knows about it, and with the new HBO thing, he was talking about how those guys on that hockey podcast or whatever was talking about it, and how they were saying they think that she did it, but that you're never going to get 12 people to agree that she did it, that you're never going to get 12 people to convict her. And I almost, if they're not going to get a not guilty, I almost would rather them get another hung jury and the Commonwealth decide not to prosecute her again. But I don't know. I don't know what's going to happen. Oh, I don't know if you guys heard me. I don't know if it's still there or not. I got a notification. I don't know where it went. Lawyer, his live today says jury problems for Reed and Vallow. How can we prevent this? I don't care about Vallow. But I want to know what he's talking about as far as Reed is concerned. So, I got to watch that. I'm assuming it's because so many people know about the case. Because Vallow's case is well known too. That woman's cray-cray. I don't even care about her. She's a child murderer. I know this trial is about her husband's death, I think, but still, I don't care about her. I know, like when I call to report that my electricity's out, they're like, do you want to call back when it's restored? And I'm like, why would I need a call back? When it gets restored, the lights are going to be back on. I think I'm going to know that the electricity's back on. Okay, guys, I'm going to go cook dinner. I hate to cook. God, I hate to cook. Oh, remember we were talking about I love you presents yesterday? So yesterday, remember we had the shorter break yesterday, so I didn't take a break. I didn't even eat lunch. I just sat here and talked to you guys. So I texted Travis. I'm like, I forgot to take anything out of the freezer for dinner. I was like, do you want to bring food home? Or do you want frozen dinners? And I didn't text him, bring home whatever. I was just like, I gave the choice to him. And I love barbecue pork sandwiches. Like I could eat one every night for dinner. I love them. He got sick of them. So he quit going to get them for me. Because I would like every day I'd call him. I'm like, can we please have my favorite tonight? So yesterday, like I didn't tell him. I figured he was gonna come home and be like, no, we'll just eat frozen dinners tonight. So when I got up here, I was in the bedroom playing a video game, and he came home and he didn't say anything at first. And then Belle's like jumping around all happy, and I'm like, what are you so happy about? You're happy to see Daddy? And he goes, well, Belle, do you smell something? Do you smell something? Go tell Mommy. Tell Mommy to pause the video game. Let's go. And he brought me my favorite. He brought me my barbecue pulled pork sandwich. So tonight I have to cook. Unfortunately, I hate to cook. Yeah, that's like YouTube sends me a notification when I go live. Yeah, you think? Yeah, I know. I just went live. I know. Okay, guys, I love y'all. I will see you tomorrow, bright and early, for more Phil Spector, and then for more of this. Spinach and feta cheese. I've never had feta cheese. I love spinach. I have loved spinach. When I was a kid, I would eat cold spinach right out of the can. I love spinach. Travis hates it. I love it. Still to this day. Bye, guys. Enjoy your evening, and I will see you tomorrow bright and early. Bye.